Welcome, Dr. Prachi, to this platform of Zucate Matter Mantra. This is our second episode, and it's such a pleasure to have you here amongst us. And I'm sure our audience that comprise professionals, academicians, students, and others would definitely gain a lot. And design, as we all know, pervades our life all through, right? Whatever we see, there is an element of design when it is, it gives an identity, it gives a character, and it is also very attractive to the consumer. Needless to say, a design enhances the brand. It enhances the brand value of the company and also the overall competitiveness in the market. With this background, today we will discuss with you right from the evolution of design and how it has shaped, particularly in India, and the implications, the ramifications thereof. So let's begin, Dr. Prachi, a little bit about the brief evolution of design laws in India.
Okay. So, ma'am, to start with, I will start with World Trade Organization. Now, WTO, you all must be knowing it's a big international organization. The main reason why this organization is working is to take care of trade-related aspects. Now, these trade-related aspects can be related to goods or services or intellectual property. So one organization which is dealing with trade-related aspects is dealing with the trading of goods, services, and intellectual property. Why so? Because intellectual property is also a property which can be traded between different countries. And hence comes an organization which is called TRIPS. Trade-related aspects of intellectual property. This organization is actually by World Trade Organization, and hence we know TRIPS organization. This organization basically takes care of all the international trade aspects of intellectual property, wherein intellectual property can be a patent, a design, industrial design we say. It can be a copyright, it can be trademark or geographical indications or trade secrets or integrated circuits. All these categories are related to intellectual property. So this is taken care by TRIPS. TRIPS is an agreement. Now here we should know what exactly is an agreement. Agreement is a legal document which is being signed by multiple companies. So it is a multilateral organization, multilateral agreement which is signed by multiple countries, and India is also part of that. So hence TRIPS organization takes care of intellectual property rights. In this TRIPS agreement, it is stated some kind of standards are stated. These are the standards which are to be followed by all the countries, that how we are going to protect the intellectual properties of different creators and inventors, and how it can be used for public welfare, how it can be used for technology transfer and enforcement, so that public can benefit out of those intellectual properties. It can be used for public welfare. So hence this is why TRIPS is there. And so all the countries are given the leverage, are given the independence that they can implement these standards which are laid by TRIPS through their own particular local acts. So that's why India has Indian Patent Act, Indian Design Act, Trademark Act, and Copyright Act, Geographical Indications Act. And these acts, why are they? They are here to provide you guidelines, to provide you all the ways by which they can implement the standards laid down by the TRIPS. So that's how we have Design Act, which is actually not formed by TRIPS, but because of the guidelines laid by the TRIPS agreement, we have formed Design Act, Indian Design Act, to implement those standards. Okay. So this is how we started. Yeah.
What about the Paris Convention that happened in 1883, which is said to be among the first that kind of put a system to this entire process of design patenting or design thing, and also followed by then the Hague Convention in 1925, which is, I think, if I'm not mistaken, often referred to as the Hague system. So what are the implications of these in the Indian context?
Yeah, so see, TRIPS agreement, see, it's found in almost 1967. But before that, there was an organization called WIPO, World Intellectual Property Rights Organization. So I think, TRIPS came into existence in 1995. And so in 1960s, around 1967, World Trade, this organization was there, WIPO, which takes care of all the intellectual property rights. So what TRIPS has, a particular new standard is to follow the conventions ruled out by WIPO. So the conventions ruled out by WIPO are Paris Convention. Another one is Hague Agreement, as you told, Rome Convention, Berne Convention, and IPIC. These are so many conventions. I'm giving you some examples. There are so many conventions laid down by WIPO, created by WIPO to promote and to manage intellectual property easily and, you know, in a smooth manner, so that countries can manage it in a better way. So what TRIPS has said is the basic standard is to follow all these conventions. Now, why Paris Convention is there? Paris Convention is used for the smooth and proper functioning of, it lays down the standards relating to patents, industrial designs, trademarks, and geographical indications. It doesn't include copyrights. Copyright is another intellectual property right. And copyrights are ruled out by, the standards of copyrights are provided by Berne Convention. Similarly, Hague Agreement is an agreement between multiple countries to provide you the standards, the rules, the guidelines that how internationally different kinds of designs can be protected between different countries. Hague Agreement is particularly for designs. But here I must include one more line, that India is not part of Hague Agreement. Okay. India, yeah. So we are talking about India here, and India for now, we may come in future. Intellectual property rights are growing in India. So we are evolving, and soon, as far as I can see the growth, I'm into this market, I'm experiencing day and night with the intellectual property. So it's not, soon we will be the part of Hague Agreement also, which lays down the standards, international standards for design protection. Nonetheless, the Paris Convention, this convention, India is part of this convention. India is part of Berne's Convention, and Paris Convention lays down standards of following how we can go for the international protection of patents and designs and trademarks and geographical indications, not copyrights. That is followed by Berne Convention. So through the rules laid down by Paris Convention, we protect designs in India. And those rules are particularly guided to a specific inventor or a legal representative through Indian Design Act of India, which has been amended so many times. So why Paris Convention is here is to provide you guidelines, international guidelines for how to follow the international protection of the designs.
Okay, so like you said, that the Indian Design Act has been evolving, and it is still, I would say that as the digital space grows, as designs come in there, I'm sure there will be further amendments and look at it, right? From, let's say, the Design Act of 2000, then it went on to Design Rules of 2001, and then it was further amended. Am I right, Dr. Prachi?
Yeah,
it's further amended, right?
So many times. It has
right up to 2014. And in 2014, I think it incorporated, from what I read, it incorporated a new category of applicants as small entity in addition to natural person and other than small entity. So what does this exactly mean? What exactly is it?
Okay, so there are 3 types of categorization. So we rule out for design, not only for designs, for any other intellectual property as well. And those are, one is natural person, another is small entity, and third, small entity, or we can say sometimes startup as well. It's like small entity / startup. They can also be included in this category. And one is large entity. So natural person is like an individual. Suppose I or you may want to file a design in on our name, or maybe a group of individuals who try to file a design as a creator of that design. So if you want to file a design in your particular name, we have to file as a natural person. We are a natural person. We are an individual. So it's a legal term used to represent just one person or a group of people applying for a design in his or their name. Okay, so that is individual person, which is natural person. Now, if we talk about small entity or startup, MSMEs, according to the guidelines of MSME, there is a category which is micro, small, medium, and large enterprises. So those small entities and startups, as far as the guidelines are laid by MSMEs, these are those categories which are very smaller in scale. Startups are really, which are just struggling for their businesses, and small entities are a little grown-up versions of the businesses, and large entities are, they are matured enterprises. So pricings of filing the designs are different for all these categories. It's minimum for a natural person, and it's a little increased for startups or small entities which are growing, which are developing enterprises, and which are developed enterprises like large entities. For those pricing is a little increased. So that's why government has segregated, so that everyone is able to file designs comfortably within their price ranges. Yeah.
Thank you so much. Can we just go a little bit more into the process, right, from registration to design infringement, to how do you protect a design? So protection of design. Let's just begin with the process for the registration of design. And if you could substantiate it with, let's say, examples of the 3 categories that you mentioned. How does one go about? And yeah.
Okay, I'll take an example of a natural person. If you wish to file a design as a very natural person, you've created a good design. Now it's really appealing to the eyes, and you want to protect it so that you can commercialize it, and no one other can. You want to make your property it as a property. That is the significance of intellectual property. Okay, so firstly, personally, my belief is, though you can file on your own as well, you should always include a legal representative of yours, an attorney, because those people are really experienced in doing these things. Because we have gained this experience from so many years by dealing with different cases, and it's really hard for an individual to file on his own because of so many legalities involved in it. Now, firstly, there is a list of forms which are to be filed on the design of patent office website, and there is an option of e-filing on the patent office website, and through different forms we have to firstly file our design. How? There is a form of application of design, which is form 1. We have to fill in all the details which are asked by the government in that application form. There is one rule of filing the representation sheets as well along with the form 1. Now, in that representation sheet, whatever your design is, you have to very clearly represent all the angles of that design: the front view, the back view, the side view, left side view, maybe the right side view, maybe any kind of perspective and isometric views, or maybe bottom view, top view, every kind of view where the novelty lies. The government asks you to prepare those views on maybe some professional softwares like AutoCAD, and different types of softwares are available, and you have to represent those angles on different sheets, maybe suppose 7-8 sheets are required, a PDF file of that is prepared, and in the footer of every sheet, you have to mention the disclaimers and novelty part of your design, where the novelty lies, and disclaimers and about what exactly is not being included in that design. Because some kind of designs may have some kind of property marks, some symbols which you don't want to protect. They are just representing your company name or so like that, but you have to protect the design. So such kind of disclaimers are, it's really required to be mentioned to avoid any kind of objections from the government. So here I come with the word objections, which is the next stage after filing. After filing with all these forms like representation sheets, form 1, a power of attorney if you are filing with a legal through a legal representative. If you are a small entity or a startup, you have to file a form 24 as well, and you have to file some priority documents also if you have filed in some other country and then you are filing in India, or maybe in India and then you are filing in some other country. So priority documents are also required to so many legalities are involved. That's why I say legal representative should always be involved in this. And after filing, government checks and scrutinizes your application. It comes up with objections. Objections may or may not be there. Depends on the professionalism laid by the applicant or the legal representatives. We deal with so many applications, and sometimes objections just don't come because we file them so properly in a very proper format. Because if objections come, then additional fees is involved in that, and you have to pay that fees and professional plus government fees. You have to fight with the government, with the design patent office for your design, and by various kinds of objections and replies to those objections, and maybe a hearing may be there. You may be having a face-to-face meeting with the examiner or controller, registrar or controller, we say, of designs. And after all those hardships, within a span of 6 months, which can extend up to maximum of 1 year, but within 6 months, we get a design granted. And if it is really novel, original, and it is as per the standards of the Design Act, and we get the design registered then. So this is the whole procedure of registering a design.
Great. Thank you very much, Dr. Prachi. We've already got some questions coming in, but let me just ask you a couple of more questions, and then we come back to one of the questions posed by our audience. And on this note, I would like to mention that anyone who has a question, kindly post it in the chat box, and we will take it up either interspersed during the conversation or slightly later, but we will definitely take up all your questions. Before I go to the question posed by one of our audience members here, I would just like to ask you, when can you say that there has been a design infringement? How can one protect design?
And this is very good question, because that's why we protect our designs, to protect it from any kind of infringement. Now, what is design infringement? Supposingly, very successfully, you have registered your design. You have the certificate with you that this is my design, which is registered, and you are working with it. You are creating business out of it. You are commercializing it. Now, what is design infringement is, maybe some other party, some other business, some other individual in India, if you have registered the design in India, I'm talking about India, has misused your registered design, which is already protected. You are using that design for your commercial purpose, and some other party, without your consent, without your approval, uses that design for their personal benefits. So they don't take any kind of approval from you. They simply use that design of yours for their personal benefits, for maybe creating some business, some earnings, and that is actually hitting your business now, because your clients may be going to that party, maybe they are selling it at a low price or so they're infringing your right, which is intellectual property right. So that infringement, which is without your approval, someone is using your intellectual property, someone is using your design, is called design infringement. So that is basically design infringement, because that person should actually come to you, ask you, and you may ask for some kind of royalties. You may license that design to that person through your approval, through some legal agreements, and you are earning royalties out of it. So that is a proper way of getting approval from some someone to getting permission from someone when you have a property over it. So if that is not done by someone, that is design infringement.
Okay. And how can one protect the design?
Yeah. So supposingly this kind of an act is done by someone. Now, here we should note is if you have not yet registered the design, you are hopeless. I mean, anyone else can use your design for their personal benefits. You have not taken any right from the government for your design. You don't have the certificate. You have no right to stop anyone else from using the same design. If you have already disclosed this publicly, now it's like you have publicly informed about your design. You have not protected also as your legal property. So someone can use it for their personal benefits and you cannot stop it. So this is one part of the story. Second part is you have registered your design, you have done all the technical legal work, and you have it as your property. Now someone is using for their personal benefits without your consent. You can file a case against that person very easily. And you can, ask that person legally through courts, any court which is higher than a district level of court. You can simply go there, file a case, and bound that person, force that person to provide you back all the injunctive reliefs, all the payments, all the financial losses that you have gone through because your design has been used by that person without your consent, and your clients have gone into the hands of that person. So you can ask for the financial losses, and he has to provide that financial loss, which can range from maybe minimum 25,000 to a maximum of 50,000. So this is the price range actually laid down by Indian Patent Office. The infringement reliefs, other than other kind of release, that you can stop that person for any kind of future acts like that. But as far as the financial reliefs are concerned, government gives you an authority to take back 25,000 to a maximum 50,000 from that person who does this without your consent. So it's a good benefit. It's a really great benefit. Yeah.
Okay. Let's take two. Yeah.
For one design, I must say there are multiple designs, so that money is multiplied with that count. Yeah.
Okay. Let's take two questions that have come up before we move on to the next. One is from Dhananjay. So Dhananjay asks that for international design and patent filing less than in 8 countries, should we go through PCT or individually filing in each country?
So that's a very professional question. I think he's into this.
Has to be a professional.
Yeah.
Yes.
Yeah.
We have another from a law student. So let's see what that comes in.
Okay.
Let's take this one first.
Yeah, glad to have this question. Hi. So the answer is, as far as my experience is concerned, what I feel is that had it been maybe the case may be related to patents or related to designs. If the count is less than 5 or 6, okay, if the count is less than 5 or 6, you can go for each individual country, and through the legal representatives in that country, you can go for the filing of design or a patent, because that's not a big count, and I think those expenses can be managed. But if the count of the countries is more than 5 or 6, this is an approximate idea, you should go for a PCT mode of filing. PCT mode of filing is for patents. Now, as far as international filing of designs is concerned, we can only go through Paris Convention, because PCT is for patents and Hague Agreement is for designs, and India is not part of that agreement, I must say. So you have to go with for Paris Convention only for as far as designs are concerned, and according to Paris Convention, you can file individually in different countries. So soon, if India becomes the part of Hague Agreement, it will be easier for us to file in multiple countries through a single application mode. So that's the answer. Well, this answer is actually my personal experience, which may vary as it depends upon the financial status of every enterprise or an individual. Because if we go by patents, for patent, if we go by PCT mode, it really reduces the financial burden which is faced by any individual or an enterprise. Because for developing country like India, 90% discount is given by PCT WIPO for PCT filing. Almost 90% fees refunded back. So it comes down to 20,000 to 30,000 only for just one filing an application. And then examination is a different process. So this is my experience that if it is less than 5 or 6, go for individual country filing. And if it is more than 5 or 6, you can go for PCT. Yeah.
Great. I'm sure that would answer the question posed. Before I go on to the next question, which is slightly on the privacy law aspect, how do you evaluate? You used a term which is also there, appeal to the human eye. Now, appeal to the human eye is a very subjective perspective, if I may say so. So how do you then evaluate what is appealing to the human eye? What does it entail? Are there any specific guidelines?
Okay. So to answer this question, I need to differentiate between patents and designs. So see, patents are actually related to some concept which an inventor has created, which relates to so many technologies and invention having so much of R&D work. Now, this is one part, which is patents. As far as designs are concerned, designs are not related to technical concepts of any product. Designs are related to how that product is different and how the designing of that product is done. That part, which may be very functional for maybe having some very good kind of aesthetic value, maybe appealing to the eyes, and hence the marketing aspect of that product includes. You know, we all are so much excited by different kinds of designs, and hence the market comes up with different designs. You know, so those designs are always protected because that increases the commercial ability of that product. So that is which is appealing to the eyes. If I say, maybe you have a Coca-Cola bottle, so it has a particular kind of a shape associated with it. Yeah, although it has been protected as a trademark, but I'm just giving you an example that what exactly is design means. Suppose, if I talk about Apple iPhone, the technology behind that iPhone, that is protected as patents. But the designing of that product, how that phone looks like, how sleek the body is, and how the softwares look like in between. So that look, which really appeals a person, and he's, so it becomes excited to buy that product just by seeing it, its body looks and how it looks like. So that is a design which should always be protected because it really increases the market value. And being a person who really likes different good designs, I know that how it really increases the commercial value of a product, and hence intellectual property rights. One of the intellectual property rights is designs. Yeah.
Great. We have a question from a law student. This is Shlok, who asks, is there a strong connection between data privacy law and IPR? With data privacy law expanding, it will not be limited to just technology. So what do you think? How important will data privacy law be in the field of IPR?
See, since I'm talking to a law person and me being related
to a law student
is
what they say.
Yeah, law students. So data privacy law, as far as I'm able to understand, is some kind of a different kind of a law. Data privacy law. I think it's related to some kind of confidentiality agreements, how we can protect the data. Data privacy, if you can just explain, I can understand is related to some kind of hacking, which should be protected, or it may be related to some kind of confidentiality agreements which are signed by a company to protect their marketing strategies. So data privacy, data can be related to a company's data, or it can be related to data which is available online and which can be hacked by any other person. Now the question is there any strong connection between data privacy law and IPR? So what I believe is that data privacy is something very different from IPR, but yes, in some cases, these two things are similar because they protect something. Okay, so protection maybe by privacy means by hiding something, And another protection is by not hiding, because once we protect through IPR, it is it's a public disclosure, which is, government gives you IPR rights in exchange of a fact that you have to disclose everything about your design or patent to the public, so that technology can grow and businesses can grow and new technologies come up, technological advancements take place. So you are not protecting here, you are disclosing everything here, but you are given a right that if someone misuses that disclosure of yours, you can stop that person by suing that person for infringement rights, or you can ask for royalties. Now, data privacy law is something it may relate to confidentiality agreements as well. There is a company law for that, it's a corporate law for that. And the data privacy may be some related to hacking as well. So there are different aspects of privacy, and one of them is intellectual property law. It's rights, and it may sometime relate to it, sometime it may not relate to it. And government has laid down different kinds of laws to protect different kinds of things. One is IPR, one is data, one are company forms and all that. So it's like it depends on case to case.
Thank you very much. Let's just move on a little bit here, and as we are talking about the data privacy, we are talking about the online space. What would you say would be the key differentiators between the copyright and the design patent, and when should one take which route? Because sometimes there is a possibility of an overlap or a kind of a gray zone. So how does the person figure out which route to take?
Yeah, actually, I really feel like answering this question and again, because there is so much need of awareness regarding this, how copyrights and designs can be differentiated. And I'll start with an example. So that example actually students are easily able to understand. Supposingly, there is a fashion designer, and there is a design of flowers printed on maybe a drawing sheet, and he uses that design of flowers printed on a drawing sheet on his dress which he has created. He prints that design. Now that product, which may be a big gown or maybe some kind of jumpsuit, that is a product. A design of flowers is a design which is on a drawing sheet. He prints that design on a product, which may be a suit, which may be commercialized and sold to some other person who wants to buy that dress. Now that this dress is a product. Now this is a copyright, which is on a drawing sheet, and this is a design, which is a complete product, which is jumpsuit. So what difference you understand is, copyrights are actually literary, that is one part, related to novels and books, and for artistic works. Artistic works may be like a painting, maybe some artistic craftsmanship work. It may be related to some architectural aspects also. It may be, so this kind of flower design is actually a painting or a drawing done by some artist. So that protection can be taken up by a copyright. Now, when you use this copyright on any dress, now that once you use that copyright on a dress, that dress is a different product which can be protected as an industrial design, because the design is a product on which you have laid down. You have created one product which is a jumpsuit, so you have to protect it as a design. And once you do this, the copyright on that flower design does not subsist. It completely expires once that design is laid. The copyrighted design is used on that product, for that product. This is the difference between copyrights and designs. Why I need to answer this question is because copyrights are also provided for artistic works. Designs are also provided for given for artistic works. So where is the difference? Now, design is a product and copyright is an artistic work which can be used on that design. So here lies the difference. And the government rules says that once there is a copyrighted design and you copyrighted art craftsmanship work and you use it on a design, copyright on that work expires as soon as you do this work. This is one rule. Second rule is, if there is a copyrighted work and you do not register it as a design, if you register it as a design, copyright on it expires. If you do not register it as a design and you sell that product at least 50 times in the market, the copyright in that product automatically expires. These are some of the rules laid down by the government, that how we can differentiate that this is a copyrighted work and how it has transformed into a design. So this is the basic difference, how the things are carried by the acts. Yeah.
There's another question that is related to this. I mean, since you also mentioned the craftsman and the artistic work. We have all seen that in the recent past, there's been a little bit of a controversy in the fashion world with Sabyasachi and the H&M product. Now, that is, the controversy there is slightly different, but what I would like to ask it is what happens with folk art, folk kind of craftsman work. Now, a product like this, it is designed by the particular fashion designer's art studio, right? But it is primarily drawn from the folk culture, let's say. How then does it play out in terms of infringement?
Okay, so means you are saying some design is related to folk culture.
Yes.
Okay, so there are two things involved here. So if there is a right for geographical indication also, which protects the things originating from a particular location, having some which have their value because of that origin only. So we need to firstly check if that can be protected as geographical indication as well. Because if that folk, if that culture, or maybe something originating from a particular origin, that is specific to that origin only, and it has significance just because of that origin. Significance because of that origin. So some dances are protected as geographical indications, products like basmati rice, and when we go as a tourist to different states, we know wow, this is the speciality of that state, and we specifically buy that products because it is having some kind of significance which is related to that origin. So that we need to firstly check, because the example you have given, it has to be checked through different cases if it can be protected as geographical indication as well. Number one is this. If I take this apart, take the concern of geographical indications one side. If I talk about folk as something, it's a dance category, and it can never be protected as designs, but it may be, we may think of copyrights here, because copyrights not only protect the literary and artistic works, but also the works related to cinematographic, related to dances, related to musical compositions, related to songs. So lyricists and producers and directors always go for copyrights. It completely protects the whole film industry we have right now, broadcasting industry. So if that folk is some kind of a short play, supposingly that folk is not a folk as a whole, it's kind of a play in which some country specifically in their particular dance, in their particular dress has done some dance of 5 minutes, and they want to protect that dance video of 5 minutes, that can be protected as copyrights. So this is the exact way of differentiating. Folk as a whole is something different, which can be protected as geographical indication, which is related to that origin. Now, a video, a dance, a script, a story of 5 to 10 minutes, that can be protected as copyrights if you want to protect it and commercialize it. So that is the difference between geographical indications and copyrights in relation to folk. Yeah.
Great. Because I think both the Designs Act and the Copyright Act, they do mention when what kind of design is excluded from the ambit of that particular act.
Yeah.
Right. So the Designs Act will exclude artistic work that is provided under the Copyright Act. And the Copyright Act will exclude designs from any protection under it, which is registered under the Design Act. So I think both the acts have made it very
very
clear.
clearly mentioned in each and every act, such as like related to architectural aspects. These are protected as copyrights, not design. Someone get confused that architectures, sculptures, all those can also be protected as designs, but no, they cannot be protected as designs, but as copyrights only.
Great. So would you throw some light on what is piracy of design? And how should one be vigilant about it? Because today's the space is too vast. So to be vigilant, one has to adopt certain very well thought out mechanisms. So what is your thought on that?
Yeah. Sometimes, there is some kind of confusion, but having experienced this market, the word piracy and infringement means the same here. Piracy means, someone is misusing your design. The word piracy and infringement reflect the same fact of misusing someone's property of design without the consent. And it has been misused in some other way. A way maybe piracy, a way maybe infringement, different kinds of ways. So one should be vigilant, definitely vigilant. Why? Because it's your property. How can it be pirated by someone else? And it's, if I talk about the market, sometimes if I talk about patents, it's a way of earning. This using the infringement is a way of earning for businesses. Sometimes they actually they are completely having eagle eyes in the market. People are having eagle eyes in the market that who exactly is misusing their legally protected intellectual property. And once they find that person, they either go to that person in his office to negotiate and sign a legal document of licensing and earning royalties, or if that person doesn't agree, they simply file a case if they find their site to be very strong, and so as to earn financial benefits from that party because of the wrong work they have done. So we should be very vigilant, because it gives you so much professional benefits out of your intellectual property.
Interesting. I mean, this is it's a very interesting space to be, to try and kind of figure out all these nuances that have very large implications. And like you mentioned, all the examples from the industrial examples to design in terms of product over fashion over an idea. I think it's a very exciting space, to really monitor, to learn, understand, and absorb. Many people do wonder, how does one locate facilitators for design patent? So how does one go about it? And what is the role of, let's say, the Delhi Innovation Council for that matter? How does it facilitate, how do these bodies facilitate ease of registering a design patent?
Yeah. So as far as design and patent facilitators are concerned, the Indian Patent Office gives you the list of all the facilitators which are representing you, which can represent you for design registration. And we actually have a team of such facilitators. We provide such facility to come to us and protect your designs. Actually, it is really required, because for a person, though that person can file the design or patent on his own, but there are so many legalities involved, and we are still learning. As a legal person, we are still learning. So it's really difficult for a person who is very new in this field, is very novice. So all the list of facilitators can be seen on the Indian Patent Office website. All the patent facilitators can act as design facilitators also, and there is a special list of design facilitators also available on the Indian Patent Office website, but that list includes only 10. I had actually I can see, I know, so I can see that only 10 design facilitators from all over India are listed there. So but the list of patent facilitators is a bigger one, and all the patent facilitators can actually file the design also. So this confusion should firstly be resolved. You can check for patent facilitators only. They can file your design as well. Okay, so that list is a bigger one. Secondly, these facilitators actually need to work as per the government norms. Some kinds of discounts are also provided by SIPP for small and startup entities if they can prove that they are actually small entities registered under the Government Act, MSME. They are registered as small or startups, registered as startups. They can avail some kind of discounts which are particularly given by the government for filing their patents and designs. There are some discounts also available for them. As far as Delhi Innovation Council is concerned, me being the president of the council, we are dealing with the innovations from different, I must say pan-India, but it's Delhi Innovation Council. We are focusing majorly on Delhi, and we promote innovation here. We promote innovation, and through my company Intellect Bastion, we promote intellectual property. That means protection of that innovation. So both my workplaces, Intellect Bastion, we protect the innovation, and through Delhi Innovation Council we promote the innovation. So promotion and protection comes, it's balanced beam which I follow daily from day and night. Yeah,
that's amazing. I think you're doing brilliant work out there. And we'll be happy to take more questions if there is any. But otherwise, I would definitely want to ask you a high point in your work experience so far related to IPR, and one very critical point, something that you would like to share,
related to
something that is very exciting, which was really very challenging for you. And it's a great example to know.
So as far as lawyers are concerned, something very challenging for them firstly is to create, lawyers are so much working like freelancers also, and to as far as intellectual property rights are concerned, when I was not into this kind of a work, I was actually, India is like a place which is so much unaware of intellectual property rights. There is so much need of awareness. In fact, I was also like wondering, should I go for this career or not? Are there so many, will this section grow? Will people like to protect their intellectual property rights and so? But I must say, this is really a growing field, and it's growing very exponentially in India. Just recently, I have listened to a news of announcement made by Piyush Goyal that now for universities and institutes also, the fee for filing design, which is actually 8,000 for government fee, has been reduced to now 1,600 only. The government has reduced the pricings. For filing the patent so much, and government is trying so much to grow the intellectual property in India. Government is working at its best these days. They have reduced the pricings, and even as far as our cases are involved, the examination reports which we were getting in 2.5 to 3 years, now we are getting the reports from the government offices in another 1 year or so. Means the time is also reduced. That's why I must say intellectual property is a big field which will hit the empire. It will cover all over India very soon, and we are going to grow so much, and everything will be based on intellectual property. Like in US, you see from shoe to everything, a small mark, everything is like an intellectual property, and they talk in terms of intellectual property, and soon in coming years in India will come into that list. So really protect your intellectual property rights. If you have done some kind of good creative work, good inventive work, always protect it before commercializing it, before going into the market. I must say to every creator, every inventor, always protect your right like any other property right, like any other property. Yeah.
This has been really, really very insightful discussion. And I think with the government policies, the kind of action that the government has been taking vis-a-vis IPR and protection of intellectual property, copyrights, design. It's promoting this whole culture of innovation. And I think, and we can see it right from the education policy, where the idea of innovation is being instilled right from the school stages. To, like you said, the facilitation has become so much easier, so much faster. I think as a nation, we are here to just progress and grow and be a power to reckon with when we come to this space of IPR and innovation. I'm happy to say that we have in our midst Mr. Sanjeev Majumdar from NRDC. It would be nice, Dr. Sanjeev, if we could have your comments, if you and your thoughts, if you would like to share with us. It would be really very nice. Dr. Sanjeev. I'm not too sure whether he is able to hear us. But the fact that he has been present through this discussion, I think also means a lot, and that's wonderful. I think we could end on this note today. And thank you so much, Dr. Prachi, for this amazing conversation with Zucate Matter Mantra. And I'm sure this is going to be very, very beneficial to all those who have heard us today. And once we have it uploaded, I'm sure there will be many more beneficiaries to this. Thank you so much on behalf of Zucate, on behalf of our team, and brilliant, wonderful conversation. Thanks a lot for your time.
My pleasure.
And thank you so much to all the audience members.
My pleasure, ma'am. Honored to be a part of this conversation. Thank you so much.
Pleasure. This is just the beginning, Dr. Prachi.
Yeah, definitely, ma'am.
Yeah?
Cheers to this.
Thank you. Thank you so much. Thanks a lot.
Okay, so ma'am, I leave
Bye-bye.
by this.
Yes.
Okay, bye-bye. Take care.
Bye. Thank you.